Good afternoon, everyone. I'm Dora Kaufman of the law firm Liebler Gonzalez and Portuando, and welcome. On behalf of the Florida Bar's Standing Committee on Professionalism, Education, and Resources Group, we're delighted to present this webinar on 2024 Perspectives on Professionalism, which will include updates as to the professionalism process, the new CLE requirements, current issues, including artificial intelligence and its impact on professionalism, and some practice pointers. I will be briefly introducing the four panelists we are privileged to have and the mediator, and then turning the floor over to our mediator, Carol Link, a former chair of our Standing Committee on Professionalism. Our first panelist, Judge Nicholas Mizell, United States Magistrate Judge for the Middle District of Florida. Prior to July of 2019 taking the bench, Judge Mizell was a civil trial and appellate attorney for nearly 20 years, including commercial litigation in domestic and foreign jurisdictions. He is very active in professional and community organizations, with a particular emphasis on scouting. His sons are both Eagle Scouts and officers in the U.S. Army and Air Force. His daughter is quite on the way to becoming an Eagle Scout. He is a federal judicial liaison to the trial lawyer section of the Florida Bar and a strong advocate for professionalism, including his service as editor of the Florida Bar's Discovery Handbook. He is a former president of the Collier County Inn of Court and soon to be president of the Lee County Inn of Court. Our next panelist is Judge Fabienne Fahnestock. She is a judge with the 17th Judicial Circuit for Broward County, Florida. She earned her Bachelor of Science in English from University of Miami, her MBA from Nova, and her law degree from UF. Before her appointment in 2017 to the bench, she was a complex commercial litigator and appellate attorney, and she also worked with the 4th DCA. Among her many honors and distinctions, she was named in Best Lawyers in America for Trusts and Estates, a Florida super lawyer, and a rising star by the Daily Business Review. She's been listed among the 100 outstanding women of Broward County. Most recently, she has received the Friend of the Bar Award from the Broward County Bar Association. She's lived in Broward County most of her life and strongly believes in giving back to the community, and has definitely done so through her charitable and civic work. Our next panelist is Gary Lesser. He is the immediate past president of the Florida Bar and a managing partner of Lesser, Landy and Smith, a third-generation personal injury law firm. He's a native of West Palm Beach, and Gary is one of the foremost personal injury lawyers. His dedication to the Florida Bar is longstanding, 25 years of service, more than a decade on the Board of Governors, chairing the Legislation and Professional Ethics Committee and serving on the Strategic Planning, Disciplinary Review, Communications, and Board Review on Professional Ethics Committees. He's highly respected in the legal field and frequently serves as a guest lecturer on various topics, including professional ethics. He has been heavily involved as a community servant and has had various leadership positions in numerous organizations, including Legal Aid Society of Palm Beach, the Jewish Federation of Palm Beach, and the Martin County Chamber of Commerce. He has recently received the Sidney Stubbs Professionalism Award from the Palm Beach County Bar Association. And the last, but certainly not the least of our four panelists, is Brian Tannenbaum. At Bast Amron, LLP, he has served as special counsel and general counsel, chairing the firm's Ethics, Professional Responsibility, and White Collar Defense Group. He has been listed in Best Lawyers in America, and he has authored a book, The Practice, Brutal Truths About Lawyers and Lawyering, published by the ABA. He's a featured speaker throughout the country on issues of criminal justice and ethics. He's a past chair of the Innocence Project of Florida and previously served as president of the Florida Association of Criminal Defense Lawyers and its Miami chapter. He is a member and vice chair of the Florida Bar Grievance Committee and currently serves on the bar's Professional Ethics Committee. He currently serves as a member of the board of directors of the Association of Professional Responsibility Lawyers. Mr. Tannenbaum also, importantly, was one of the presenters at the now mandatory Professionalism Resources and Expectations Mandatory Professionalism CLE for the Florida Bar. Before introducing our moderator, Carol Link, and turning the floor over, I wanted to give a special shout out and thank you to Rebecca Bandy and Katie Jones of the Florida Bar, who were instrumental in planning and presenting this program, and to our Education and Resource Committee, including especially Judge Jack Weiss, Joshua Resnick, and Carla Ellis. And now, Carol Link. Carol Link is a shareholder and managing partner of Link and Rockenbach in West Palm Beach. She was previously a staff attorney at the 4th DCA. She has had many accomplishments, amongst them her service as chair of the Judicial Nominating Procedure Committee, chair of our Standing Committee on Professionalism, on chair of the Grievance Committee for the 15th Judicial Circuit, and as a commissioner of on the JNC for the 4th DCA. She was also a presenter at the mandatory CLE on professionalism and numerous other professionalism programs. I'd like to turn the floor over to you, Carol.
Dora, thank you so much. I am so grateful for the opportunity today to talk with our esteemed panel members who each in their own area of expertise have dedicated their personal time to improving the state of professionalism among our bar members. I truly believe knowledge is key, so let's get started. Today we will cover, as advertised, our new CLE requirements, latest updates to professionalism in Florida, current issues involving professionalism, and last but definitely not least, how to prevent discipline. Our past president, Gary Lesser, if we could start with you, you could tee us off. If you could tell the audience a little bit about the Supreme Court opinion that came out, the in-re code for resolving professionalism referrals. For our listeners, I'm going to go ahead and type the Southern Third citation in the chat. And if there are any questions as we go along, please feel free to, for our attendees, please feel free to type your chats and we'll try to answer them as we go or at the very end. So Gary, could you tell our audience about the new CLE requirements that were in that Florida Supreme Court decision?
Absolutely. And so good afternoon, everyone. I'm going to talk about if I'm really on top of things, I might be able to drop the opinion into the chat. And it looks like I did it. Surprising myself, this has exceeded my previous level of technology. So let's see, here's the big test, if I can share my screen. So we're going to give that a shot. So hopefully you see perspectives on practicing with professionalism. So I was asked by then Florida Bar President Mike Tanner to co-chair the Special Committee on Professionalism with Elizabeth Hunter. Our moderator, Carol Link, was one of the many outstanding lawyers and judges who served on that committee. We did a lot of work. And the ask was a pretty heavy lift. 3 things: to improve how and when professionalism is taught in the course of a lawyer's career. Number 2, necessary changes to the definition of professionalism and current professionalism standards. And number 3, improvements to professionalism standards with a focus on local professionalism panels. That was the lift, and we did it. So this is the opinion. This is not meant for any viewer to read unless you have better eyesight than me. I want to focus on the 3 major things that the court did. The first thing that the court did when it issued its opinion, it adopted the recommendations. The Special Committee on Professionalism worked for a year and made a series of recommendations. The first thing that the court did is they replaced the 2013 code with the Code for Resolving Professionalism Referrals. That was the work product of the Special Committee. It enhances the important roles of professionalism panels. It recognizes the importance of peer-to-peer assistance with resolving professionalism disputes between lawyers and made a very clear distinction between what's minor and an occasional deviation from professionalism and repeated violations and poor behavior, which turns into a violation of our rules. And my friend Brian Tannebaum will be talking about that in a little while. Second, they amended the professionalism expectations and other documents that form the core of the professionalism documents, the oath, the creed, and specifically changes were made in order to make clear that all communication, not just in court, but online, verbal, audio, remote, all of that is covered. It was not really clear because we didn't have these issues back in 2013. And then finally, the change that was made involved the CLE requirement, which did two things. Number one, it lessened the number of CLE credits in the 3-year period from 33 to 30. People tended to like that. But more importantly, the previous requirement was one professionalism CLE in the course of 3 years. And what we learned was often the case, that was an add-on. It was an add-on. You could go ahead and do a CLE on corporate law or real estate law, and you get your little add-on, and now you've satisfied the professionalism requirement. In order to really make sure professionalism is taught correctly, it's a 2-hour course every 3 years, and it's offered specifically by the Florida Bar, and it's free. And the goal is to, as Kara said, education is important. The more we know about professionalism, the better we're going to be at it. The other thing I'd like to briefly discuss is the Florida Bar's mentoring program called Counsel to Counsel. That was one of my priorities when I was president of the Florida Bar. And we did a survey before I was president to see if the membership thought a mentorship program for newer lawyers that were on their own was a good idea. And the result was that 82% thought that was a good idea, which was astonishing. There's a recognition, especially in the age of Zoom, the days of going to the courthouse and meeting a mentor, those opportunities are largely gone. So we had to build a mentoring program. It's been done before. Most mentoring programs fail because the mentee wants a new case, the mentor wants to tell war stories. There had to be structure. The structure is an online platform. Mentors have to have 5 years. It says 3 in the parentheses. That's wrong. Mentors have to be lawyers for 5 years or less, mentees 3 years or less in firms of 3 or fewer lawyers. And you sign up doing a personality profile, putting in information about yourself, your preferences, what are you looking for? Same circuit, same area of the law, and then a very brief personality test. The whole sign-up process takes just a few minutes. The program is in its first year. We have almost 400 lawyers participating. And this is what a match looks like. There has to be substance to it. So the Special Committee on Mentoring designed a curriculum. So there are regular check-ins talking about milestones, not, hey, how's it going today? It's the mentor and the mentee talking about networking. It's talking about how to run a law office. It's talking about the lawyer-bar relationship, client development, and community involvement. It's been said that mentoring is the easiest way for a more experienced lawyer to pay forward concepts of professionalism to newer lawyers. So the sign up for Counsel to Counsel for next year, you'll hear more about it probably in June. You can sign up by September. Those are the 2 topics I was asked to cover. I've covered within my allotted period of time, and I'll stick around for questions later.
You did. Thank you so much, Gary. I just have one quick question for you. The mentoring program, I know that's near and dear to your heart because it was part of your presidency platform. Did the Florida Supreme Court opinion that came out last summer mention, I know it didn't mention your program, but has a reference to mentoring in the opinion, correct?
Yeah, that's correct. And the court has been highly supportive, and Chief Justice Muniz recorded a video in support of the mentoring program and has spoken about the mentoring program as he's gone around the state. If you're on this Zoom call and you're a lawyer for less than 3 years, look into it, and I'll drop the link into the chat. And if you're a lawyer for more than 5 years and want to get some CLE credits by being a mentor, it's really rewarding. I have a mentee, and it's really going great.
It's great. Thank you so much, Gary. I'd like to ask Judge Fahnestock current issues in professionalism. You're in our Circuit State Court, and you've served, I think, 7 years in Broward County. Thank you for your service. You must have encountered many professionalism issues over the years. Can you share with our audience some current issues that you see percolating in your court, and how you handle them?
One issue that we see frequently, not just in the civil division where I sit, but in almost all of the divisions where attorneys set their own hearings, is sometimes the struggle when you're trying to set a hearing and the other side is unresponsive or unavailable in perpetuity. And you really need these motions set, especially in light of the current atmosphere that we have, where we are pushing cases forward. Continuances are not being granted as frequently as they were in the past, and you're running up against deadlines. And I encounter that almost on a daily basis. The struggle is real. It is. But first place that I would start, if I was a practitioner facing, these challenges, first place I would start is with the division's procedures. Many judges take this head on and put it in their procedures, what you should do, how much time has to pass where you haven't gotten a response after a request for cooperation in setting a hearing, and what options you have available to you. If your assigned judge or the jurisdiction that you're in doesn't have the procedures to do that, the best advice that I can offer as a former practicing lawyer who faced this, but also as a judge, is be reasonable. Please do not wait until 4 o'clock in the afternoon to say, here are the proposed dates. If I don't hear from you at 5 o'clock, I'm just going to unilaterally set it. That is not going to be looked upon favorably, and it's really not fair to your opposing counsel who could be in trial or depositions. Give them at least 48 hours to get back to you. If it is something that is time sensitive, or if you know that the time slot is not going to be available within that 48 hours, perhaps you can go ahead and take that slot. But if opposing counsel gets back to you and is not available, make accommodations. If after reasonable efforts, then reluctantly, you can unilaterally set it, but make sure that you explain either in your motion or at the onset of the hearing all of the efforts that you've made in trying to mutually set the hearing, the reason that you couldn't wait any longer, and then hopefully the judge will be understanding and will hear it, especially if opposing counsel is there. If they're not there, you might have some other challenges, and the judge might take an extra step or two just to ensure that due process has been afforded to the parties and everyone has an opportunity to be heard.
Thank you. I'm really glad to hear you address that. I looked online, Judge Feinstock, and you have divisional instructions that are very clear, requiring, I think they say all hearings must be coordinated with opposing counsel. And as I write as an appellate lawyer, must means must, shall means shall, and those are mandatory commands by the court. And so trial lawyers ask me all the time, what do I do? I have a special set. I need to get it set. I go on the online scheduling docket and I have a hard time getting the other side to respond. And by the time they respond, a week later, the date's gone. And so I have to go back. Some of the lawyers use the UMC process and they file a motion to special set. It seems like that would clog your docket. It's unfortunate, but in that instance where they're really diligently trying to set that hearing and there is some, there's just not a good working system there for whatever reason. Is that a mechanism or a vehicle, a motion to special set and then set that one-page motion on UMC? And do you receive those, or what are your thoughts on that?
So I get them all the time. There are some judges who actually just have a docket to set hearings. You come in, it's almost a calendar call, and you stay and you say, I need an hour for this, and they're given dates right away. I don't have that luxury. So whenever I see the motion to set hearings or a CMC, because they're having those challenges that you're talking about, I always read the motion. If it's just, hey, judge, there's no availability, I refer them to my judicial assistant. And I'm not telling people don't do it, because then you get referred and either she can assist you in the process or she can give you your options. If the motion says, I'm trying to set this hearing, but opposing counsel is uncooperative, well, I leave that motion on and then I handle it myself. so that I can see what's going on and why we're having such difficulties in trying to schedule the hearing. And usually they will resolve themselves. I will say this for anyone who appears in front of me, I do not give out dates myself. In the past, I've done it a handful of times. I've set hearings on days when the courthouse is closed. I have triple booked hearings. So if your judge tells you they don't set hearings, they might be like me. I leave it to the professional, my JA, she's amazing. And she manages to find time where time doesn't exist. I don't know how, but you know, it goes back, and I hate to use the word because this is why we're here, but it goes back to professionalism. You have to extend courtesies that you would want extended to yourself. That's the golden rule.
I'm so glad you said that. It is the golden rule, isn't it? I have an attorney friend of mine who keeps asking me, why do we talk about professionalism so much? Isn't it just the golden rule? And it really is at the end of the day. So we do fall back on that when you can't find the various resources that are all in that Florida Supreme Court opinion that form our standards of professionalism. When in doubt, it is the golden rule, right? Treat others the way you would want to be treated. So, Judge Fonnestock, one last question for you on the local professionalism panels. I know that Broward had before the Supreme Court opinion came out and really formalized and crystallized the LPP process, Broward had another process or another kind of professionalism panel. But have you had occasion to use that LPP process? Have you made referrals and had that?
Usually, when I have made referrals, the parties have come to reason and apologize, because before I just make an automatic referral, I bring them in and I explain, these are the issues that I'm seeing. And I try to give the attorneys an opportunity to explain themselves. And because no one wants to have that referral. As an attorney, I think I would be mortified if I ever was referred to the Professionalism Committee. And we are all entitled to a bad day. Okay, we just want to make sure that that bad day does not remain a permanent mark on our record, or it doesn't rise to the level of discipline. And so I have found that when those situations arise and I bring the attorneys in on a CMC and I explain to them, these are my options, this is what I'm contemplating doing, you know, I'd like to hear from you, and I give them a moment. They do apologize, they do understand. It has been very rare for me to have to go to the next step, but I have found that the panel is very effective, because if I don't get the message across when they're sitting, you know, across from their peers, people that they have practiced with or against, who are, you know, reputable members of the legal community, and they are explaining the errors of their ways, it almost always gets resolved, and then you don't see it happen again.
That's really great to hear. And the Supreme Court opinion from last summer actually mentions the LPP and identified it as an informal peer-to-peer mentoring approach. And that really what it was intended to be. It's a positive kind of didactic setting with no permanent marks on your records. And every LPP I've served on, we've discussed the point that this is kind of the last stop before you go to the bar grievance process. And so we're here to help you, bring you back into the fold, and, you know, let's look at what happened and what resources we have to get you back on track. So thank you so much for your perspective, Judge Fonnestock. Thanks for your service. Judge Mizell, it's so great to have you and have you address the federal perspective and what you see going on. And in particular, something very current and very relevant to our professionalism issues that we see today, which is artificial information. I read a recent report and recommendation of the Grievance Committee from the U.S. District Court, Middle District of Florida, and it was prompted by your referral of an attorney to that Grievance Committee, and it involved AI, involved professionalism and a potential violation of Rule 4-1.3. So can you tell our audience today a little bit about either that case or just in general what you see in terms of artificial intelligence or artificial information, AI, and professionalism?
Yes, glad to. Thank you. And maybe as a backdrop, before I forget to mention, we, in our civil action orders that are docketed in every one of our civil actions, right when the case gets here, whether it's originated here or removed, the first thing we docket is a civil action order that makes it an order of the court for everyone to abide by things like the Florida Bar professionalism expectations, the guidelines for professional conduct that are promulgated by the trial lawyers section. So we put that right in the order, and maybe that's something that when you're dealing with someone on the other side that's not returning your calls and emails, you could cite back to that order and incorporate those expectations and say, hey, the court has already ordered you to be prompt in your communication and conscientious in your communication. I would hope that would be helpful along those lines. And then on the artificial intelligence issue, that was it was interesting how that cropped up. It was a case that was brought here from state court, and that was one of the issues at play. Why it was referred, it was essentially an improper removal. But then opposing counsel was engaging with the attorney who brought the case here, both in state court and when it got here. There were a variety of citations and a variety of papers that were filed that opposing counsel couldn't find. And they would ask this lawyer, I'm trying to find these cases and I'm not finding them anywhere. Could you send me some copies? Of course, copies were not provided. And the lawyer never really was very forthcoming about where those cases were coming from and where they might be. And obviously there was a suspicion that they were fictitious, or I think some folks call them hallucinations of artificial intelligence. And so when the case came to me and I was looking for those cases and I couldn't find them, I was asking the same questions. And for whatever reason, the attorney didn't want to be forthcoming with me either about where those cases might be found or whether or not they were in fact real. So unfortunately, it did end up becoming a referral to our grievance committee. And thankfully, our grievance committee very rarely has anything referred to them. I take the same approach that Judge Fonstock was talking about. I mean, if something is starting to happen in a case and lawyers aren't playing well in the sandbox or things are going off the rails, I would bring them in here first and talk to them and try to avoid a referral. So that would be my first tack. And I did try to get this lawyer to engage and explain himself and be forthcoming and take responsibility and correct his ways, but just would never engage on those opportunities. So it became a referral and the grievance committee worked on it. And our grievance committee, I think from our perspective, from the federal court's perspective, I think takes on a dual role. We expect it to take on both that professionalism panel role that you see in the state court system, but also the disciplinary role if they need to. So my hope was that once the grievance committee engaged and talked to him, that it would stop there. It would be that peer-to-peer conversation, and he would be, take responsibility and confirm he was going to change his ways and that kind of thing. But for whatever reason, he chose not to respond to their inquiries and to not engage and to not own up to what was going on. So yeah, it did end up becoming a full investigation by the grievance committee, ended up becoming a full report and recommendation. And they did find multiple violations of a variety of bar rules, as you mentioned, the diligence and promptness rule, the failure to disclose proper legal authority to a tribunal rule, and also a rule prohibiting dishonesty, fraud, deceit, and also because I had made my attempts to try to get him to let us know where these cases were coming from, and he wasn't engaged on that. They also found a violation of disobeying an order or an obligation imposed by the court. So, and ultimately, he's essentially barred from practicing in the Middle District of Florida now. And I think that's essentially an indefinite suspension because the penalty, he's not eligible to be readmitted until a variety of things are completed. And if anyone wants to find it, it's out there on Westlaw. If you might run into a problem where you think opposing counsel are using these fictitious or hallucination type sites, you might want to direct them to this one. It's called In Re Newsome. It's on Westlaw at 2024 Westlaw 101397. And that's Judge Steele adopting in full the recommendation and report from the grievance committee. And this lawyer, before they can be readmitted to the Middle District of Florida, they have to attend a variety of professionalism programs and counseling with the Florida Bar, pay any and all outstanding sanction awards that have been entered against them, and there were a variety of them along the way, and any other remediation the Florida Bar might impose, because we did end up referring this also to the Florida Bar for their own investigation and potential discipline. And we also had some other impositions about, rereading professionalism expectations and certifying same. So I don't expect, well, like I said, I think it'll probably be an indefinite suspension until all those things are taken care of. And I've had some other things also crop up that I could talk about as far as professionalism go. I tell you, I make use of what the Center for Professionalism website and the programs that are available for free. A bunch of professionalism CLEs that are available. And when we haven't been able to get lawyers to improve their ways just by our own interaction with them here in the courtroom or in our orders, and they continue to adhere to the tack they're on for whatever reason, then sometimes I will require them to attend these courses that are on the Center for Professionalism website. Again, reread the oath and creed and expectations and certify same, also some monetary sanctions and things like that. So, and I think another thing we're pressing against, at least to try to raise the bar, so to speak, on professionalism is maybe the over-reliance on video conference and not actually meeting each other and seeing each other. And so I continually try to encourage them and have in-person hearings and try to foster that collegiality that I think in-person interaction fosters. And I think a lot of times we're encouraging them. I mean, a lot of times I'll tell them, I would go out to lunch with my opposing counsel during the middle of a deposition. There's no reason why you can't do things like this. Go get a cup of coffee together, get to know each other. You never know. They could end up being a great friend. They could end up being a referral source or a colleague or a co-counsel, even though they're opposing counsel now. So there's a variety of relationships that can be formed. And I always try to underscore that whenever we are admitting new members to the Florida Bar. A lot of those same things. I know they kind of grew up in the COVID Zoom world, and we try to encourage them to make sure they're interacting in person as much as possible, because I think that can only help us on the professionalism side.
There's no doubt. Judge, thank you so much. Not only that Newsom opinion it's an important read, I think, for lawyers to avoid not just the fallout and the sequelae after using the artificial intelligence and not owning up to it, but all of the steps that occurred in that. It's a road to not take all the way. But thank you for your comments about the in-person, because Zoom really did impact our professionalism, right? In terms of when you go to a hearing in person, you would have a few minutes before the judge takes the bench to say hello. And, hey, how's your son, your daughter? Before we started this Zoom here today, my friends and I, we chatted about our children and, what's new going on and how we're doing. And we do belong to a special group. It's unique. It's a privilege to belong to the Florida Bar. So it's nice to feel like we're family and we care about each other. And I think we lost that connection in the Zoom era. So I'm grateful and glad to hear about your comments to the new lawyers. They need to hear that so that they know that's what we do, and it's how we've been doing it for so very long. And so thank you for your comments about the Newsom and artificial intelligence. Is there an order in your court that you know of about the use? I've read some orders around the nation. And I know the Florida Bar is looking at a proposed amendment to our rules regarding artificial intelligence. But is there any order in the U.S. District Court, Middle District, regarding the use and certification by counsel of artificial intelligence in their memorandum motions?
Right. No, not right now. We have talked about it. I think the prevailing thought is that most things that you would associate with a misuse of artificial intelligence is already addressed by a variety of rules and ethical and professionalism expectations. So we don't know if there's necessarily you need to add to that just for AI. I think if you maybe AI is just another tool in the toolbox, right? And a lot of things we always do with technology assisted review of documents or document production that we've been doing for decades, or using Westlaw. I mean, a lot of things that already have AI components to them. When you're doing a natural language search in Westlaw that we're all familiar with, I mean, we've already been using artificial intelligence in a variety of ways. We just need to avoid its misuse, and it's obviously, and in some respects, probably folks should be using it in their practice. We just need to use it properly.
That's true. That's no question about it. Well, thank you so much, and thank you for your service. Mr. Tannenbaum, I have saved the best for last, or for some lawyers, the worst for last, right? The road definitely not to take, but you have such a broad wealth of information in the area of how to prevent discipline. I'm so grateful you could join the panel today. What would you tell some of our attendees, your best top 10 or less, about how to avoid that formal grievance process? Because there are two paths. There's that local professionalism panel, informal path that I mentioned earlier, doesn't go on your bar record, and it's more of a counseling, peer-to-peer mentoring. Come back to the fold, don't stray, don't drop those bad words in an email, count to 10 before you hit send, all of those things. But when they come to you, that's a different process. That's a formal grievance. So can you tell the audience a little bit about how to avoid that formal process and the bad road?
Sure, and I am honored to be here with the panel, especially who you've invited. Gary Lesser has been a leader in professionalism, which is much appreciated, to have a bar leader who focuses on this stuff. And Judge Mizell and Fonnie Stock haven't said this, but I'll speak on their behalf, that judges hate this stuff. When lawyers can't get along, it delays things. It causes issues for litigants. It causes what's called prejudice to the administration of justice. And it's just not something that should exist in the profession. And one thing that I always tell lawyers is that there's ethics and there's professionalism. And those are two different things. Now, we've had a little merging, which I'll talk about. But ethics is what you can and cannot do. Professionalism is what you should and should not do. And they're different. Now, what the Supreme Court of Florida has said is kind of in a casual way, we're tired of all this stuff. So what we're going to do is say that a violation of the oath of attorney where you engage in offensive personality is now a bar violation. And so when you read a formally filed bar complaint in the Supreme Court of Florida these days, you'll often see rule violations cited, and the bar will cite that the oath of attorney has been violated. So going to a professionalism panel is, in this world, a great thing, because you're going to get spoken to, you're going to work things out, maybe you have to do a CLE. But once you go down the bar road, where bar counsel gets involved and they're investigating, they're determining whether your case is getting filed in the Florida Supreme Court. So professionalism, in my 30-year experience, is more discussed than ethics. When we go to cocktail parties, we don't discuss whether somebody's competent or diligent or has a conflict of interest. We talk about their reputation. We talk about how they treat other people. That's all professionalism. So the first thing I'll say, which angers a lot of lawyers, is that you're a lawyer 24/7. Lawyers believe that they're only lawyers when they have a case, when they have a client, when they're in court. But that's not the case. You can be disciplined for conduct from the moment you wake up to the time you go to bed. And that includes at a bar, at a restaurant, at an airport, not paying a court reporter, getting in an argument with a shop owner. All of those things can and do result in bar discipline. So when you became a lawyer and you took the oath of attorney, you gave up some rights. You gave up your First Amendment right to say whatever you want about a judge. You gave up your right to behave in a certain manner at all times. So there's a lot of anger out there about that, but the bar more and more is focusing on how lawyers behave. So the first thing I wanted to say was just keep that in mind. That's the way things are. You are a lawyer 24/7. Number two, my favorite thing, pick up the phone. When we first got cell phones back in the 80s, it was the most amazing thing that somebody would call us. Now somebody calls us and our first question is, who's calling me? Why aren't they texting me? Why aren't they emailing me? And we often start a relationship in a case with an email, and maybe not a nice email. I like to pick up the phone. I like to call lawyers. I like to talk to them because voices sound different than emails or text messages or even letters. Now, there's certain lawyers that you can't do that with. They're untrustworthy. You have to do everything in writing, and I understand that. But when you're beginning a relationship in a case, regardless of how it began with you, I would pick up the phone. Oftentimes, a letter writing campaign ends in a phone call and the case gets resolved. That is one of my top pieces of advice, is pick up the phone. The other thing I'll say is never go to the bottom. And that means you practice law the way you practice law, not the way someone else practices law. At the end of the day, when all these emails get attached to motions and they go before the court, you want your emails to read professionally, because judges are pretty smart. They see what's going on. They see a barrage of emails being sent to you and your professional responses, and they're going to rule in a fashion that's going to indicate that they understand what's going on here. So don't respond to another lawyer the way that they are conducting themselves with you. Your job is to lower the temperature, not to raise the temperature. And in saying that, I have a favorite phrase, which is hit save and not send. Your immediate response to a negative email is never good. And I advise you to type all you want and hit save and go to bed and read that email tomorrow. And I guarantee you, you will not send that email. I guarantee it. There is no prize for responding immediately, even if the email you received said, I need to hear from you immediately. And by the way, if I had one wish in the bar, it would be that the word immediately is an ethics violation, because nothing happens immediately and it shouldn't. Just like Judge Fondystock said, give lawyers some time. Okay, everybody needs time. Technology is causing us to do things much quicker than it used to be, and lawyers need time. So do not respond to anybody immediately. And if you're typing that email, do not send it, because as we know, E in email stands for exhibit. The other thing I'll say is take a break and take a walk. And what I mean is, if you feel like you're getting heated, if you feel like you're about to say something that you don't want to say, either on the phone or in an email or otherwise, stop. Take 10 minutes, get up from your desk, take a little walk, take a breath, and deal with it in a way that if a judge is reading the correspondence at some point, and that may be a federal judge, a state court judge, or a justice on the Florida Supreme Court, you want them to see you being professional at all times. And the last thing that I'll say is, don't ever become your client's ego. A lot of what happens in professionalism is based on what clients want. They don't like opposing counsel. They don't like the opposing party. Obviously, they want you to do certain things, and they want you to be their mouthpiece for their anger. And that's why litigants hire lawyers, because we're separated from the emotional aspect of what's going on, and we need to behave that way. When your client tells you, I don't want to agree to any extensions of time, you have to tell them at the initial consultation, I don't work that way. I am required to give reasonable extensions of time. And by the way, I'm going to need them too. So I'm going to give them, because when I go on vacation, or when my wife's having a baby, or when I'm sick, or I just want to go to my kid's soccer game, I'm going to ask for that extension of time, and I want it granted. And I don't want to hear, well, you were being unreasonable. So when you're dealing with your clients, deal with them at the initial consultation. Let them know how you work, and behave in a way that when you're engaging with opposing counsel, you let your client know, I need to be professional, because that's the way your case gets resolved. Thank you.
Brian, thank you. And that last point is our 7th professionalism expectation, which is titled Independence of Judgment. An enduring value of a lawyer's service is grounded in the lawyer's willingness to exercise independent judgment in practice and while giving the client advice and counsel. So that it really is an important part of not being your client's ego and that's our job, is to exercise our independent judgment and explain our level of professionalism and how we're going to treat opposing counsel. I also would add that professionalism is less costly than the other path. If a client really questions your methodology of how you approach something, it costs a whole lot more money to file motions and fight and emails and all of that. I've seen it, and as appellate counsel and records have reviewed and been consulted on, and so there is a cost factor. So it really is our duty and ethical obligation to help our clients help themselves sometimes. And so that is a really compelling point. That's an excellent top 10 list. And Brian, thank you so much. We are coming up close on the close of the hour. So before we end, I just wanted to, I don't see questions from the attendees. I know we have several hundred people watching the Zoom, so it's possible that we have questions that I can't see. But we have an outstanding Florida Bar resource in the Henry Latimer Center for Professionalism. Ms. Bandy is on this Zoom link, CLE, with us. I don't know if there are any questions from our audience that Ms. Bandy can see that I can't, or if there's anything else that our panel would like to add before we close out our Zoom CLE today. You're back.
Okay, thank you. There seems to be a little bit of a delay, so I apologize. We do have a question in the chat. It says, lately I've had serious resistance from the older lawyers on appearing in person for depositions. How do you recommend we address this issue in a professional manner?
Brian?
I think that depends on how many witnesses you have, and maybe there can be a compromise that certain depositions are taken in person and certain depositions are taken on Zoom. I have that issue actually in a case right now where we've had some agreements about in person and on Zoom. But if you have a lawyer that's just unwilling to agree to how the depositions take place, you have to make a decision whether that's a battle that you want to fight and take that before a judge, understanding that judges are busy and they're going to look at you and say, well, why does it really matter? And if it really matters, well, I've got 3,000 documents, that I want to show this witness, and or something that is going to get a judge's attention, then fight that battle. Otherwise, I say move on.
I could also add, I think too often when I see these issues crop up for us, it seems that the lawyers are forgetting that for a deposition, at least in federal court, to take place by remote means, it has to be by agreement. It has to be by stipulation. It's not the default. You can't just notice a video deposition. If the other side doesn't agree to it, you're not entitled to notice it that way. So we are consistently reminding folks of that the default is in person. So if you have any problems having that in-person deposition, at least in our court, you can expect a quick order from me saying it's going to be in person. Similarly, I wanted to also on that consult with client. Say I can't agree to an extension without talking to my client first. We do see that sometimes. There's a meet and confer certification that's required in motions. A lot of times someone's just looking for a little more time on, I want another week or two to file an answer, or I need a brief extension on a discovery response. And the certification will say, well, I talked to my opposing counsel, but they say they need to talk to their client first. Now, we're going to grant that motion instantaneously. And I'm probably going to require, I might have a hearing and have explained to the opposing counsel, that is not something you need to talk to your client about. Or I might just at least say that in the endorsed order. Thankfully, I know I'm blessed with having lawyers that work with me and can take care of these kinds of motions, so we can jump on them. And I wish my brothers and sisters in the state court system had law clerks as well. So thankfully, we can jump on those things and dispose of them and not, have to wait to have a, set a hearing and then talk about it at a hearing. But that's how we would handle things like that.
Excellent point. Thank you.
There are a couple other comments and I guess questions in the chat. Oliver says, from the judges, best way to deal with unilaterally set hearings on a date when you've explicitly said you have a conflict. If you have to show up to defend the unilateral setting, you've endorsed the unilateral setting. And then Carmen also says, as an old timer, Florida Bar member since 1969, I find it interesting that older lawyers object to in person. On video, you can't see all the subtle nuances, nothing like face to face.
So if I can jump into Mr. Ragg's question about that is a problem. You see a notice of unavailability, and then you see a hearing has been set. How do you do it? Because that if you get coverage, then you've overcome the obstacle. What I have seen attorneys do is, file a motion for continuance of hearing. Hopefully you can get that heard before the hearing, but if you cannot, and I can only speak for myself, I review the docket, I review the motions. If that motion for continuance of hearing is uploaded with the supporting documents prior to the hearing, and I see I'm unavailable, here's why, I'm in trial, or I was already on vacation and this was set and I don't have Wi-Fi capabilities, or whatever the reason is that constitutes a good basis, I'm going to have a conversation with the setting attorney when they do show up and say, well, I see this. Did they advise you that they were unavailable? Well, yes, Judge. Then why are you setting it? That's a very different conversation than the other side just didn't show up and has been unresponsive. So probably that's how I would handle it, unless, again, the judge that you are in front of has different rules or different procedures.
Thank you. Thank you, Judge. Rebecca, is that all of our questions for the day? I think we're close to our time limit for our 1 hour professionalism.
We are close. I'm looking through the comments and questions in the chat, and it looks like everything. One more comment. It says, on the issue of mentoring, is there an opportunity to provide mentoring to new attorneys that elect to pursue a career in prosecution or criminal defense?
Okay, I have an answer to that. I've actually had my computer fail and come back and fail and come back in the last 30 minutes. So now I'm on my phone. So persistence. So when the program was first launched, I think the initial thought was more civil law. And as we started building the program, we realized that it's really important to have criminal. We heard from a number of state attorneys and public defenders across Florida that they do their own mentoring. What we ended up doing at the very end, Rebecca just dropped a link for Counsel to Counsel. What we ended up doing when we launched the program this year was to include any lawyer, 3 years or less, civil or criminal. And that's actually been helpful. The people who participate choose the practice area that they want to match up with. It's very important. And I believe the plan going forward is to have civil, criminal, 3 years or less. And I think that would be very beneficial.
Good.
Sort of a simple, straightforward answer from a lawyer. Go figure. But take a look at the link, please, everyone on the call that Rebecca just put in the chat. You'll learn a lot more about the mentoring program, and I encourage everyone to participate.
Absolutely. And don't hesitate to contact our office. So the assistant director of the Center for Professionalism is Katie Jones, and she's phenomenal. And she is the staff liaison for the mentoring program, Counsel to Counsel. And she can answer any questions that you may have. And her email is it's Catherine. So it's C Jones. I always have to correct myself on that. cjones@floridabar.org. And I'll put that also in the chat. But her name is Katie Jones, and she is very passionate about this topic. And then also, if you're going to be at annual convention this year, there will be an informational booth available in the lobby for everybody to check out and get some more information as well.
That's really great, Rebecca. Thank you so much. And thank you for the center's help in promoting this today. And for everyone on the Zoom link, I'm going to give you the CLE info reference number for your 1 hour credit. It's 8517. And I just want to thank you, each one of you, for being servant leaders to our bar and for everything that you do. Thank you for leading us today and for helping us learn more about professionalism. I hope everyone has a really great day. This was a really fun program for me, and thankful for you. Have a good day, everyone.
Thank you.
Thank you. Thanks, everyone.
Bye-bye.